Was this a delay tactic more than it was a this is going to change the outcome tactic, kind of putting some space between the actual crime and when this goes to trial, hoping maybe people's minds, it's further off in the past and they're less impacted by the drama of it all?
Generally speaking, delay is always a friend of the defense. And perhaps that was a piece of the motivation. But also, I think she really wanted to get it out of this locale where everyone, or virtually everyone, at least according to reports, has kind of vilified this guy, the accused, Bryan Kohberger, who's presumed innocent. And she needed to make sure he got a fair shot. And so that I think was the primary motivation. And so we're going to get into a new county now where hopefully people's minds are not as made up on this issue.
Are we going to see more delay tactics, whether we call this one or not? But there certainly has been a few that seems to have been that. Do you think we're going to continue to see that as we get closer and closer to the date, or are we just kind of are we running low on that in our tank of things to fire out?
I think they're going to look for every opportunity they can to delay. I think that only potentially helps the defense, and especially in a capital case. Like you said, they want more time to have gone by between the incident and the trial. But they also, when delay happens, people's memories get fuzzy. Witnesses move out of the country. There are issues that can happen with the prosecution as a result of that delay. So I'd expect to see more.
They had to have weighed the pros and cons here on this. I would think of, okay, if we do go to another county to try this, we don't know who the judge is going to be. We don't know where it's actually physically going to be. What is the lesser of the two evils? Do we stay here with Judge John Judge, who seems to have been fairly impartial on this? He's been hearing the case. He's been talking to both sides. I don't think he felt like he weighed super heavy on one side or the other. But you could get a judge that's not like that. You could get a judge who is, even more opinionated on this case. That's got to be kind of a, roll the dice. Who ultimately makes the decision on presenting this? Is it the attorney? Does the client have some say in this? Did Kohberger have his say and go, yeah, let's roll those dice and see what we get?
It's a good point because they could draw someone like a Judge Gull in the
Yeah.
Richard Allen case, who was
Yes.
just horrible for the defense. So,
Yeah.
so you don't know. There's a risk there. In terms of making this decision, the client really has a say in nearly every decision, but the attorney is allowed to kind of be at the helm of strategic legal decisions. And in my mind, this is a strategic legal decision. I think ultimately it was a collaborative choice that was made by the attorney and Kohberger, but usually this comes from the attorney side.
Let's go back to the defense for a second and the alibi. The alibi of he likes to drive around and look at the stars. I mean, and Ann Taylor does not seem like a bad attorney. She seems like she's a pretty damn good attorney as well. Um, why go to that defense? Was she literally left with no other option? I mean, obviously they got to discuss this with Kohberger. I mean, what if Kohberger was just driving around looking at the stars and there was no one to have an alibi with other than some raccoons out in the woods? What I mean, if you have nothing and there's no one that can place him anywhere else, why still go with that? Is it just literally this is all we got, and this literally is the truth? So we're not gonna make something up and say he was somewhere that he's not, but it still just doesn't look very good. But we're gonna go down that road.
There are a number of defenses that can be raised, but I think they kind of fall into two categories. One category is my dude didn't do it. The other category is my dude did it, but he was legally justified in doing it. The latter category is like self
Hmm.
defense, duress, someone made him do it, that kind of thing. And when we're talking about a quadruple homicide, stabbing, home invasion, you're not gonna you're not gonna run a self defense type of defense. So she's kind of left with my dude didn't do it, and the way to bolster that instead of just doing a general denial is to actually assert an affirmative alibi that he was somewhere else. And perhaps that's the truth, and perhaps that is what happened. And so I think she was kind of relegated to that choice, and they have to kind of put all their eggs in that basket at this time.
It's going to be fascinating to see where this goes. If there was, because at the very beginning, of course, we heard the terms. We have exonerating evidence that will show that he did not do this. If there was exonerating evidence, would we not have heard it by now? So they wouldn't have to go through all of this. If it's that solid, I would think you'd be throwing that out there right away. If to just no, look here, we can prove it right now. He wasn't there. We don't have to go through the trial. Here's what we got, judge. But I'm guessing that doesn't exist, or could it exist? And we're just going through all this rigmarole just to, to go surprise.
Tony, you would think, and most folks would think, hey, if they have some ironclad way to get him out of this, gosh, why not present it by now? But on the other hand, even when I have a very solid defense for a client, I am sometimes reluctant to share that with the government, with the prosecution, because what it allows them to do is analyze the defense, find any potential holes or weaknesses or concessions that actually help the prosecution, and exploit those. And it gives them more time to do that the earlier you
Mhm.
notify them of that evidence. So it at least is not shocking to me that if they did have such evidence, they may not be super inclined to just turn it over and show their hand right now.
Because you're taking a chance, or you're rolling the dice too, of like, will the judge accept that and go, yeah, this truly is, let's throw the case out. Versus that's pretty strong, but we got a stronger case over here too. It's really kind of like a 50-50 shot.
Yeah, it's absolutely a gamble anytime you want to reveal the defense side. And that's the thing is the defense is not obligated to
Mhm.
to show their hand. They've got to make disclosures. They've got to tell what their defense is, who their witnesses are, but they're not obligated to share the details of their case, whereas the government is. And so the fact that they're holding it close to the vest is rather common practice in criminal defense.
There was a lot of bizarre things that Kohberger did when he went to go visit his parents around the holidays, packing things in baggies, wearing rubber gloves, cleaning out the back of his car, putting trash into the neighbors. And his parents were aware of this. They saw all these things happen. There's a book out that has accounts not directly with the parents, but friends of the parents who have kind of heard the backstory. When they're out for dinner, yeah, here's what's really going on, and then they find and it doesn't sound like Kohberger's family is extremely in the camp of they believe their son. They want to support their son, from what I can understand, but I don't necessarily think they're in the "I believe you" category. Can the parents be called as witnesses in this for the prosecution to say basically what happened right, when he visited?
100%. And I absolutely expect the government to try and call them as witnesses. Now, there's a chance that the dad or even possibly other family members may have some kind of Fifth Amendment privilege against self incrimination. You remember the dad sort of went with him on this cross country car ride after all of this happened. And is there some evidence that he was an accessory to a crime or helped
Mhm.
in a cover up? I don't know. But if there is, the dad could be called as a witness and then invoke his Fifth Amendment privilege. And that would just add another bizarre twist to this already strange case.
There's so many twists and turns here. There's so many pieces of evidence that we don't know about yet. The digital footprint being one of them, in terms of text messages, in terms of Google searches, and all that. In other cases, we hear some of those things early on, but that's not always the case. A lot of things are sealed in this. Do you expect there to be some pretty strong bombshells coming out of the prosecution or the defense in this case once this does make it to court?
I think once this does make it to court, yes. But I think that until then, especially with this change of motion or change of venue motion being granted, I think the new judge is going to try to take every measure to ensure that the potential jurors in the new county are not tainted by any sort of public disclosures of bombshell evidence for the prosecution or defense.
Mhm.
And so I think we're probably going to have to wait for the show, which I'm told might be 2025, early 2025, but we'll
Mhm.
we'll see about that.
I believe June, I believe, is that they have set.
June.
No
Okay.
firm date to 25, but yeah, we shall see. It's going to be fascinating. Hey, thanks for checking out the video. Be sure to follow us wherever you download podcasts, and especially Apple Podcasts, where you can get advanced episode and premium content on our premium channel right there. Also, be sure to follow us on social media so you don't miss any breaking updates on the stories that matter to you most. We're on TikTok, X, Instagram, Facebook. Just search Hidden Killers Podcast with Tony Brueski, and you'll find us right there. Again, thanks for watching.